Thank you. Chair, we next have the evidence of Mr. Pieter van der Merwe.
Yes.
If I could ask for him to be sworn in.
Yes, please administer the oath or affirmation.
Please state your full names for the record.
My name is Pieter Johannes van der Merwe.
Do you have any objections to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you solemnly swear that all the evidence that you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Yes, thank you. You may proceed.
Thank you, Chair. Mr. van der Merwe, you have in front of you a bundle of your evidence documents. They include a statement, a sworn statement from yourself, and a few other documents that I'd like to just go through with you initially so that we can orientate ourselves in the file. I've also left on the witness table the bundle of Ms. Stimpel's evidence, because there may be once or twice where I need to ask you to reference a document in those files. But if we can start with your file, it commences at page 1 with a sheet headed Statement of Pieter van der Merwe. Do you see that? Mr. van der Merwe, if you'll bring the microphone a bit closer to you and also turn it on at the bottom. Thank you.
Yes, Chair.
So that is the first document, which runs to page 10. And as I have it at page 10, it was deposed to on the 7th of June of this year before a Commissioner of Oaths. Is that correct?
Yes, Chair.
Thank you. And then what follows it are the series of annexures to the affidavit, which run, at least the sworn statement, which run to page 32. I then would like you to look at from page 36, which is another statement under oath from you, as I have it. That will be under the divider 2 and under the tag A2.1. Do you have that?
Yes, Chair.
That appears to be a second statement of yours, and if you go to its last page, which is at page 40, again signed before a Commissioner of Oaths, but this time on the 8th of April 2019. Is that correct?
Yes, Chair.
And that, as I understand it, was a previous sworn statement you provided to the Commission. Is that correct?
Yes, Chair.
Mr. van der Merwe, I understand that there are some aspects that you want to correct in relation both to this earlier statement in April, as well as one or two in relation to the June statement. As I did with Ms. Stimple, I propose, Chair, to deal with those corrections in the course of the evidence.
Yes, Chair.
That's fine.
Thank you, Chair. And then just to understand the remaining two documents in that additional bundle section, at least there are three remaining documents. The first is a CV of a person which is actually an annexure to your April statement. Is that correct?
That's correct, Chair.
And that's at what page?
That is at page 40.1, Chair.
Yes, thank you.
And then if we go over again past the next tab to page 41, this is a copy of an email which we'll deal with in your evidence, but just to confirm, I understand it to be an email that you received on the 22nd of April 2016, which you then subsequently forwarded to the Commission's investigators. Is that correct?
That's correct, Chair.
And the same applies, as I understand it, for the document at page 43. That similarly is an email you received on the 22nd of April 2016 and forwarded to the Commission's investigators. Is that correct?
That's correct, Chair.
Thank you. Each of those emails have letters attached to them, which were the attachments in the emails, but we'll come to that in the evidence.
That's correct.
Thank you. Mr. van der Merwe, if we turn to page 3 of your sworn statement, and when I say page 3, I'm really referring to the paginated pages at the top right-hand corner, because you have internal numbering which is different. But when we refer to pages, it'll be the one in the top right-hand corner of the page. Do you have that?
Yes, I do, Chair.
Thank you. And you begin there in the introductory section of telling the reader of your affidavit about the formation of GRISAG AG. Can you please tell the Chair about how that company was formed and its origins?
Yes, Chair. I met with Mr. Sergei Pokosayev, which CV is attached in the document itself. We met informally at the lodge in Zimbabwe. He was conducting business for the government at that stage. And I stayed there for a period of time, and we basically became to know each other. And I was actually asking him if there's a possibility, because I've learned that they do funding for governments, if I can introduce that similar funding to be done to South African entities at that stage, which he then agreed, and that is how GRISAG was started.
Just 2 follow-up questions. Whenabouts was that?
When I actually met him was in 2014, and the registration process was, if I'm correct, in 2015.
And you said in your testimony that Mr. Pokosayev was a representative of the government. Which government was that?
No, Chair. He previously
Thank you.
worked for both the Russian Federation and for the Soviet Union. He's age 71 this year. He worked directly under the Minister of Finance. He's with hugely experience. He's been visited more than 107 countries in his life. So he's very familiar with financing and especially international financing law.
So at the time that you met him in 2014, and apologies for the error on my part, what position was he occupying at that stage?
He was retired. He retired in 2000, and at that stage he was residing in Amman in Jordan until 2016.
And then you mentioned the creation of a company in 2015. Tell us about that. What was the name of the company and who were the directors?
GRISAG is a PTY Limited, which were registered in South Africa under South African law. And there was just 2 directors, Mr. Pokosayev and myself.
Has that remained the position insofar as directors are concerned since 2015?
That has remained until 2019, yes, Chair.
To this day?
I have changed it recently, about 3 months ago.
Right. Thank you. At paragraph 8...
I'm sorry, you have changed it. Did you say you have changed it?
Yes.
What does that mean?
We also have an entity which is based in London, which is also GRISAG. It's just AG Limited instead of the PTY Limited. There we have 4 directors. In South Africa, I have Mr. Pokosayev have resigned. I think it was in February or March, and I added a business BE component, a new director to the GRISAG AG Pty Limited South Africa.
So there's been a change of directors to some extent
in 2019.
In 2019, in regard to the South African version of the company.
Correct, Chair.
But you say there is also a similar company in London?
Registered in the UK.
Yes.
With the same name.
Yes.
We've got different entities, Chair.
It's different entities, but in substance it's the same people.
Correct, Chair.
Okay, in terms of directors and so on.
Not entirely, because
Yeah.
the South African entity has got now a BE component.
Yes, yes.
With Mr. Bokosayev
Yes.
resigning on that.
Yeah.
But in the component in the UK itself, there is 4 directors. I'm the only South African on that as a director, and the other 3 directors is Mr. Bokosayev, which is currently in Russia, and there is 2 UK citizens which are
okay.
directors there.
Okay,
Thank you, Chair.
Thank you, Chair. Can I just get clarity? At the time that the 15 billion debt consolidation of SAA was taking place, which is really the years 2015 and 2016, the company Grisag AG that was registered in South Africa, during that entire period, who were its directors?
Chair, as I stated, myself and Mr. Bokosayev since 2015 until 2019.
Thank you. And then in relation to the London entity that you referred to, we will go through your evidence with all of the various interactions that the South African company had at various points in time with the SAA's endeavour to raise funds. But was the London company involved in those interactions?
Chair, no. If I can just say, the reason for that was it was made clear to me that any business that has to be done inside South Africa must be a South African entity. So for that reason, the South African entity was registered, Chair.
Thank you. Now, at the bottom of page 3 of your statement, you start to talk about your engagements with the Free State Development Corporation. Can you please explain to the Chair how those arose, when they arose, and what they entailed?
Yes, Chair. During 2015, I think the company was registered in February or March of 2015. I basically then went to various departments and even our neighboring countries like Lesotho and Swaziland. And because I am residing in the Free State Province, I also went to Bloemfontein and I met up with the FTC. My biggest market was at that stage was for housing. We really, I tried to get a model on board where we can do the gap housing, for instance, where GRISAC then can be part of doing the funding as such. So I then met up with the FTC and I wrote them a proposal. At that stage, they explained to me that they are more interested in buying certain buildings which they rent out for different reasons. And in the documentation, there is a letter which can confirm and the date that we were talking about a possibility of funding this the buildings as such, which at that stage were a priority for the FTC. Thank you, Chair.
That letter, just for your reference, is at page 11, and it is dated August 2015, as I understand your statement. Can you confirm that that's the correspondence you were referring to?
Yes, Chair, I confirm that is the correspondence that I received from the FTC.
Over the page at page 4 of your statement, you talk about the reasons why that funding for the housing project didn't go through. Can you explain to us what the issue was there?
Chair, for GRISAC to do funding in any country for any project as such, we see ourselves not as investors. They are a funding entity, and it's private capital that they use. So when they engage in any project, they want to make 100% certain that they will be repaid. So they would insist on having a bankable guarantee, which will be the surety for the payback of any amount that is needed for a specific project as such. Thank you, Chair.
And why did that become an issue in relation to the housing project with the FDC?
With the FDC itself, they corresponded to me to say that it's very difficult because they need to get a guarantee from Treasury, and at that stage such guarantees are not available to be issued. And I even asked them, do they have a current a book with enough assets where they can issue a guarantee against that? And the reply that I got was that it was not doable for them to issue a guarantee. They were more hoping that we would use the new asset that was supposed to be bought as a payment guarantee should they not pay back. But from the funder's perspective was they do not want to end up with a lot of property in foreign countries. Thank you, Jim.
And then on the same page, page 4, from paragraph 10, you start to talk about your interactions with Seacrest as an entity. The full name is Seacrest Investments 115 Pty Limited. You recount at paragraph 10 that also began in August of 2015. Can you tell us about those interactions? Who approached you?
Chair, I was contacted by Mr. Leon Etzebeth, who is an attorney in Nigel, and he has got a representative or somebody renting office space from him. I'm not 100% certain how the relationship worked. Mr. Rambao, if I'm correct with the pronunciation of that. And they asked me if GRISAC would be interested in funding SAA, who wanted to do debt consolidation. At that stage, the amount was 14 billion South African rand.
Did he indicate to you how he came to learn of GRISAC AG as a potential funder?
Chair, they did not directly told me that they have had some engagement with a specific person. They just said to me at that stage, and that was my understanding, that there was a tender that was out for funding SAA for this 14 billion. And they made it very clear to me that as GRISAC has not been registered as an FSP provider at that stage, and we did not have any BEE component, that we cannot basically on our own tender on this specific tender. And I said that we don't have a problem. We can do a JV if it's beneficial for both the parties. Thank you.
Mr. van der Merwe, just to get greater clarity, I was interested in how Mr. Etzebeth learnt of GRISAC as a potential funder. Did he ever disclose that to you when you first communicated?
Chair, no. I cannot recall a direct time or a date that he disclosed how we met, but as I said, because this is in August of this year, I started with marketing as early as March when the company was registered. So it could have come from any source at that stage. So I honestly cannot say it was I was introduced by a specific person. Chair.
Thank you. And you've dealt with the terms on which Seacrest was explaining to you the need for them to be involved in the arrangement with SAA, as I have it. You were told two things. You were told GRISAG didn't have an FSP license, and similarly it wouldn't satisfy triple BEE requirements. And so the idea, as I understand it, is that you would then form a JV with Seacrest insofar as the funding for SAA was concerned. Is that correct?
That is correct, Chair.
And you talk at paragraph 12 about a memorandum of agreement that was subsequently entered into between GRISAG and Seacrest. A copy of that is attached as Annexure VDM 2 to your sworn statement. You'll find it at page 12. If we could just take a look at that. Mr. van der Merwe, the first thing I note in relation to this is that at paragraph 12 of your statement, you talk about a memorandum of agreement that was subsequently signed on the 27th of August between GRISAG and Seacrest. But if you go to page 15, which is the last page of this agreement, it does not appear to bear a signature of Seacrest. Can you assist us there?
Yes, Chair. The agreement was definitely signed. I just could not find the copy at that stage because it happened a few years ago, back, and the transaction went nowhere, so I did not find it as a necessity to keep it. And after I've been contacted by the Commission, I found whatever documents I had, and I prepared that. So this arrangement, as in this addendum, that is the arrangements that we discussed, and that is what we agreed upon. Thank you, Chair.
So just to be clear, despite it not being signed, I take your evidence to be you've gone through the terms as reflected here, and you're satisfied that they accord with the terms of the agreement that was reached with Seacrest. Is that correct?
That's correct, Chair.
I'd like to just highlight one or two points in the agreement. Did this agreement relate to the SAA funding opportunity?
Yes, Chair.
And if you go to page 13, you'll see clause 2.4 there. Copy is not all that easy to decipher, but I think we'll do all right. At 2.4 it says, amongst the terms, that the interest rate will be fixed at 4.5% per annum. What interest rate is that referring to?
Chair, that is the interest rate that SAA would pay back the loan when the money was paid out. So that is a fixed interest rate that we charge. It's 4.5% in this specific arrangement.
Well, can I probe that a bit further? Because if you look at clause 4 on that page, it records that Seacrest's benefit from the transaction in terms of this agreement will be the difference between the interest rate of 4.5% at which GRISAG's founders will arrange the funding for the loans and such higher interest rate as Seacrest may be able to negotiate with SAA. Mr. van der Merwe, I'll draw your attention to that because your answer to my previous question was that 4.5% would be what SAA paid. Well, can we just probe that? Because as I understand this JV agreement, Seacrest was going to be engaging with SAA. Is that correct?
Chair, that's correct. The 4.5 was the funding that was made available, but in this specific case to Seacrest itself, and Seacrest would put a certain percentage which they would negotiate for their own benefit. That percentage was never discussed with me or disclosed to me. Thank you, Chair.
Right, so you knew though the GRISAG interest rate would be 4.5% in the transaction, and you were aware from the terms of this agreement that Seacrest would add a markup, so to speak, and that would be its interest in the transaction, anything above 4.5%. But from SAA's side, SAA is going to pay the Seacrest amount, whatever it is above 4.5%. Is that correct?
That is correct, Chair.
Thank you. Chair, I see we've reached the lunch adjournment time. If it's convenient to break now, we can continue after the lunch.
Yeah, yes, thank you. So this additional interest or portion of the interest, that would have nothing to do with you.
That's correct, Chair.
It was just going to be between SAA and Seacrest.
The reason for that was because they were probing to. I was using the BE component, which were compulsory as it was explained to me, and for the fact that we would be making use of an FSB license, which I did not have at that point in time. So that will be their contribution, and that is why they sought some sort of relief in getting some payment. But what that payment amount was, that was never discussed with me.
I would have expected that the normal thing would have been that everything would be in this agreement, and that then between the two of you, you would divide what your proceeds from the transaction between the two of you, the way you would have agreed.
Chair, that's correct. That's normally how we conduct the contracts,
Yes.
but they insisted on doing it in this way.
Yes.
So this contract was not drafted by myself. It was
Yes.
it was drafted by Seacrest Investments.
Yes, and you say you never got to know exactly what percentage they agreed upon with SAA.
That's correct, Chair. I was not aware what percentage
Yes.
they put forward
Yeah.
towards the SAA for funding them.
Yes, okay, thank you. We'll take the lunch adjournment and we'll resume at 2. We adjourn.
Rise.